And you did not kill Officer Rayner because he was Jason Rayner. You killed him because he was a police officer.
And you just somebody. You sober, you did it. You sober, you him. You ran up him sober.
Not more than 20 hours a month at $8 an hour reimbursement.
In March 2017, Vicente Rodriguez Ortiz, a 22-year-old man, was involved in the tragic shooting of 50-year-old Lori Lundeberg in Grand Rapids, Michigan. Rodriguez Ortiz had been previously on probation for assaulting Lundeberg, and during questioning about a separate homicide in January 2018, he made statements that led to his involvement in her murder. In the early days of 2018, Rodriguez Ortiz shot and killed Andre Hawkins, a boy who was a friend of his ex-girlfriend. The incident occurred after an argument escalated, with Rodriguez Ortiz allegedly threatening his ex with a weapon. Hawkins was fatally shot while attempting to start a car. Rodriguez Ortiz was arrested the following day after a brief foot chase, and his statements during questioning helped link him to both murders. During the court proceedings, Javika Wallace Hawkins, the mother of Andre Hawkins, spoke with remarkable grace and forgiveness. Despite the immense pain, she told Rodriguez Ortiz that she forgave him from the bottom of her heart.
In order to get through this process, I had to forgive you, and I forgive you from the bottom of my heart. I pray for you because as a mother, you're a child to me, and in my heart, I have no anger or bitterness towards you. As a mom, I just want to hug you because I know that there's something that's not connected that made you feel so angry.
I just want to say I'm sorry, Miss Hawkins.
At his sentencing in 2019, Rodriguez Ortiz received a life sentence for the first-degree murder of Andre Hawkins and a 35 to 75-year sentence for the second-degree murder of Lori Lundeberg. In 2011, Trey Zwicker was tragically murdered in Louisville, Kentucky. Initially, his stepbrother, Josh Young, was charged with the crime. However, in a shocking twist during a 2012 court hearing, Josh Young's father, Joshua Gooker, admitted to killing Trey, claiming he acted alone.
I just wanted to say I didn't help anybody kill Trey.
Okay, there'll be an opportunity for you to make a speech to the court. Mr. Gowker?
His confession came after he had previously implicated his son, and this unexpected development led to a dramatic courtroom outburst. The confession stunned those present, including Trey's father, Terry Zwicker, who voiced his belief that Gowker's statement was a manipulative tactic.
You got somebody that's blatantly lying over and over and over, one extreme to the next. To me, it's kind of an act. At best, they say the word Gowker, every hair on my body stands at attention. I can feel the tingle. So it's just feeling that this is the right way. Justice is going to be served.
He expressed his frustration with the situation.
Alive. I mean, it sends my nerves so bad, to where my body feels just like it's gyrating. If I could, I'd jump right through the TV set, but I can't.
Gooker admitted to his mother during a jail visitation that he is taking the blame for his son.
So look, man, bottom line is, I'm just going to take this one on the chin, and God, Josh better not leave me.
That's when I'm going to light the fuse. I'm going to blow it right there.
Josh Young was later acquitted of murder in 2013, but the case didn't end there. In 2019, Josh Young sent a letter confessing to Trey's murder, claiming his father's confession was a lie to protect him. Young admitted that he had been the one to kill Trey. Despite Young's admission, he cannot be retried for the murder due to double jeopardy protections. In 2024, he was sentenced to 5 years in prison for federal charges related to weapons. But for Trey's murder, justice remains elusive. On June 23, 2021, Officer Jason Rayner of the Daytona Beach Police Department was critically injured when he was shot while investigating a suspicious vehicle. The shooter, Athol Wallace, fled the scene, initiating a multi-day manhunt. Wallace was captured 3 days later in Georgia and extradited back to Florida, where he faced charges of first-degree murder. Officer Rayner tragically passed away from his injuries 2 months after the shooting. During Wallace's trial in September 2023, the jury convicted him of manslaughter with a firearm instead of the more severe charge of first-degree murder. The prosecution argued that Wallace's actions were premeditated, while his defense claimed he acted in self-defense. During the sentencing, Judge Raul Zambrano referenced Wallace's disturbing social media posts expressing hatred for law enforcement.
Words matter. Yes, sir. They really matter. And your words were very chilling in portraying an image of you that maybe you didn't anticipate. But when those words are taken in combination with what happened here, yes, sir, it sends a terrible message. I wish I could tell you that I don't know the reasons why this incident occurred, but the truth is that you clearly expressed your feelings towards law enforcement just days before Officer Jason Rayner was killed. I am convinced, more so today than at any other time, and you did not kill Officer Rayner because he was Jason Rayner. You killed him because he was a police officer. You took a simple police investigation, something that happens every single day in our community, and then you elevated it to a violent struggle for absolutely no rational reason. Officer Rayner never suspected the execution of your plan until it was too late for him, and it cost him his life. You, however, achieved your goal, getting blood on your boots, and now you're being held accountable for those actions. Now, clearly, you hold nothing but resentment and contempt for law enforcement. And this country guarantees you and every citizen to hold to those beliefs that you want. You can hate law enforcement all you want. However, violence is not a way of enforcing our beliefs in a democratic society. In this case, at the end of the day, your biggest mistake was failing to take into the account that each human being has its own set of characteristics. That's what makes us different. Concentrating your dislikes for all law enforcement without regard to any other human characteristics is called prejudice. Based upon that, I'm going to adjudicate you of the offense of manslaughter with a firearm. I hereby sentence you to 30 years in the custody of the Florida Department of Corrections with credit for 847 days. I require you to pay court costs and convert those court costs to civil judgment.
Wallace expressed remorse in court, stating that he would act differently if given a second chance. However, Rayner's father urged the court to impose the maximum sentence, highlighting the lasting impact of his son's death. On October 27, 2023, Wallace was sentenced to 30 years in prison, the maximum allowed for manslaughter with a firearm under Florida law. In late December 2008, two homeless deaf men, Justin Murray and Michael Knights, committed a violent robbery at an Army surplus store in Louisville, Kentucky. During the incident, they killed 72-year-old store employee Daryl Spencer. A week later, on January 4, 2009, the pair visited the apartment of 34-year-old Marcus Penny, a mutual acquaintance. An argument broke out, leading to Penny's fatal with a weapon also believed to have come from the surplus store. Both men were arrested shortly after and charged in connection with the two murders. During trial proceedings, Murray claimed he was only present but did not participate in the killings. However, the jury found him guilty on all counts.
My mom takes it really hard. She struggles with it every day, as well as my uncle. He has a hard time, and his children. The holidays aren't the same. Christmas is horrible, and New Year's Eve is bad, but Christmas is the worst.
In January 2011, during sentencing, the granddaughter of Spencer gave her statement. Murray also addressed the court and apologized.
Really sorry, because I myself have seen many deaths, and I wonder how in the world people can survive through something like that. Big mistakes. The biggest lessons I've ever had my bad decision to be around someone like Michael and not being able to stop him from what he did.
He was sentenced to 2 consecutive life terms, with no parole eligibility for 25 years. Knights, his co-defendant, had earlier accepted a plea deal and received a similar sentence. In May 2013, Andrea Stokes, along with 2 accomplices, Jordan Horton and William Cowherd, brutally attacked 37-year-old Anthony Hambrick at his Louisville apartment. The trio demanded drugs and money, but when Hambrick claimed he had neither, they physically assaulted him, which led to his death. Stokes and his co-defendants were arrested and charged in connection with the murder. After lengthy legal proceedings, Stokes pleaded guilty to manslaughter in October 2023, admitting his role in Hambrick's death. In exchange for his guilty plea, he received an 8-year sentence for manslaughter and a 12-year sentence for a prior robbery and shooting, totaling 20 years in prison. Before his formal sentencing, Stokes was placed under home incarceration, monitored with a GPS ankle bracelet.
What we did was we gave Mr. Stokes the benefit of being on HIP between sentencing and the plea, because he was going to serve a significant number of years.
However, just days before his sentencing in December 2023, Stokes removed the ankle monitor and fled. The police, who were already en route to his location, arrived just as he escaped on foot. In the wake of his flight, Hambrick's family voiced their anger, feeling that Stokes had already received too lenient a punishment.
It's a family member that's gone out here, and basically the law is messed up. It's like that they're letting these people out that's committing a crime and killing families, and nothing's getting done about it.
And here it is, my uncle won't even be with us this year for Christmas, but he's out roaming.
Stokes was captured 3 days later. The escape led to additional charges. In January 2015, Judge Olu Stevens sentenced him to the full 22 years. Meanwhile, Horton was released after serving time for attempted reckless homicide, and Cowherd received a 2-year sentence for tampering with evidence. In 2022, Savannah McClanahan and Bradley Ross were accused of driving Kristen Longacre and Caitlin Raymond to a remote area in Bullitt County, Kentucky. There, the women were forced out of the car, shot, and left to die along the road. McClanahan later took an Alford plea, agreeing to serve 15 years in prison for her involvement in the double homicide. However, the sentencing for McClanahan was delayed in August 2023.
What we would like to do prior to sentencing is to have an opportunity to extract any information that is found in those phones to verify the facts of the case as we understand them. We would regret having to take this action, but we feel that in the interest of justice, it's necessary to obtain that information before we go forward with the final sentencing.
My problem is that I don't see how in whatever is found on the cell phone is going to change this agreement. And all I see it as is a delay. And I just don't, there's no direction, whether it be inculpatory or exculpatory evidence that is discovered on this phone that is going to put us in a position that this plea agreement is going to change.
The prosecution requested the postponement, seeking to extract potential new evidence from cell phones linked to the case. Despite the defense's concerns that this might only delay the process without affecting the plea agreement, the judge agreed to the postponement to allow time for the investigation. Meanwhile, Bradley Ross, McClanahan's co-defendant, pleaded guilty to 2 counts of complicity to murder. He was sentenced to 60 years in prison with several additional charges, including complicity to robbery and tampering with evidence, being dismissed. McClanahan's sentencing remains rescheduled, with her case still under review pending the investigation into the new evidence. In December 2009, a night of drugs and sex in an old Louisville home turned deadly when Joseph Bannis and his partner, Jeffrey Munt, killed Jamie Carroll. The pair stabbed and shot Carroll, then hid his body in the basement. For months, the gruesome secret remained hidden until June 2010, when a domestic dispute between Banas and Munt led police to the scene and ultimately to the buried remains. The investigation quickly unraveled the shocking details of the murder and the couple's attempts to cover it up. Banas was tried first, and in 2013, he was convicted of murder, robbery, and tampering with evidence. He received a life sentence with the possibility of parole after 20 years. In exchange for avoiding the death penalty, Banas testified against Munt, painting a picture of a toxic relationship steeped in manipulation and violence. Munt's trial came later. While he was acquitted of murder, he was found guilty of robbery and evidence tampering. He was sentenced to 8 years and released on parole in 2014. On December 30th, 2020, Antonia Lucas, 21, and Daniel Key Jr., 23, were found shot to death in a car on Lambton Street in Louisville's Smoketown neighborhood. Lucas's younger brother, who had been searching for them after losing contact, discovered their bodies. The case went unsolved for nearly 2 years, leaving their families in grief. In July 2022, Malin Harris, 24, was indicted for the murders, along with additional charges related to firearms and being a persistent felony offender. The trial began in September 2024, where the prosecution presented evidence linking Harris to the crime. They revealed phone records showing multiple calls between Harris and Key in the hours leading up to the murders. Additionally, shell casings found at the scene matched those from another shooting associated with Harris. The victims' families testified, sharing their heartbreaking stories. Lucas's mother spoke about her daughter's dreams and the profound loss she felt. Key's mother also shared her grief, describing how her son's death had devastated her.
We just was talking about things we was gonna do for the New Year's Eve, things of that nature. What would I cook for him?
Did you ever get that opportunity?
To cook for him for New Year's Eve? No.
I know this is tough. So you said you saw a foot on a dashboard.
Yes.
And did that look out of the ordinary?
Yes.
What did you do next?
Then I proceeded to open the driver door, and when I looked inside, that's when I seen both of them.
What did you do after you learned that TT had been found dead in the car?
I probably drove 100 miles an hour on 65 North to get back down there, crying and screaming to myself and wishing that the outcome would have been better.
The trial faced multiple delays, including a mistrial in December 2024, which led to motions from the defense to dismiss the case based on double jeopardy. As the case remains unresolved, both families continue to seek justice for their loved ones. Eric Conover, a YouTuber from New York known for his luxury real estate videos, is facing multiple felony charges, including attempted murder, following an incident in Bartlett, New Hampshire on March 15, 2025. Police reports state that Conover was initially spotted speeding at 55 to 60 miles per hour in a 35 miles per hour zone. When a Bartlett police officer tried to stop him, Conover allegedly brake-checked the officer, then fled. After briefly stopping, Conover backed his Jeep toward the officer, striking him and causing the officer to be thrown. The officer sustained an injury but was later released from the hospital. Conover then led police on a 28-mile chase before being apprehended. 2 days prior, he had been arrested for DUI, though he denied the charges, claiming he had been sober for over 1,500 days.
I could run this myself because I have everything right here and it's all been falsified.
At his arraignment, Conover denied all allegations, claiming he was falsely accused and asserting his public figure status. He also threatened legal action. This led to a closed-door competency hearing on March 25, 2025 to assess his mental fitness for trial. The prosecutor kept the details of the hearing confidential, and the defense team maintained that Conover denied all charges. The judge ordered Conover to remain in preventive detention, with the next steps in the case depending on the outcome of the competency evaluation. Meanwhile, the officer involved in the incident is reportedly recovering from his injury. In late March 2025, during a trip to Oahu, Hawaii, Dr. Gerhard Koenig, a 46-year-old anesthesiologist, allegedly attempted to kill his wife, 36-year-old nuclear engineer Ariel Koenig, while the two were hiking the Palipuka Trail. According to court documents, the incident began when he suggested taking a selfie near a cliff edge. When Ariel declined and started walking away, the situation escalated. Authorities say he became aggressive and injured her during the encounter. Despite her injury, injuries, Ariel managed to reach nearby hikers who assisted her and called for help. She was taken to Queens Medical Center, where she received treatment for injuries. After the assault, Dr. Koenig fled into the mountains, prompting a 6-hour manhunt that ended with his arrest near the Poly Highway following a short chase. He was charged with attempted second-degree murder and is being held without bail at the Oahu Community Correctional Center. Ariel later appeared in court with visible injuries, including a bandaged eye and a headscarf, and obtained a restraining order against her husband, citing a history of control, jealousy, and abuse. Dr. Koenig pleaded not guilty, and his medical privileges at Maui Memorial Medical Center have been suspended pending further investigation. Charlothea Bunny Holmes, a woman from Detroit, became involved in a series of crimes. In 2004, Holmes was living in Huntington, West Virginia, where she operated a small drug operation out of her home. Among the people who frequented her house was Wendy Morgan, who used drugs and engaged in sex work. Tensions arose when Morgan allegedly stole money and drugs from Holmes. In response, Holmes ordered her associates, Cedile Harper and Raphael Harris, to kill Morgan. The murder was carried out shortly after, leading to a police investigation that quickly identified Holmes as the one who orchestrated the killing. Holmes was arrested and charged as an accessory before the fact to first-degree murder. She was convicted later that year and sentenced to life in prison with mercy. Under West Virginia law, this meant she would be eligible for parole after serving 15 years. However, Holmes was already serving time for unrelated federal drug charges. This created confusion about when her 15-year clock toward parole should begin. Holmes argued that her time in federal prison should count toward her murder sentence, but the state insisted that her life sentence wouldn't officially start until after she finished the federal time, which ended in November 2011. In 2011, the West Virginia Supreme Court upheld her murder conviction, but acknowledged that her state sentence would begin only after the completion of her federal term. Fast forward to early 2025, Holmes was granted parole during a hearing, but soon after, Cabell County prosecutor Jason Spears challenged the decision. He discovered a scheduling error had allowed the parole hearing to happen too early, before Holmes had served the full 15 years from the correct starting point in 2011.
She was getting credit, she was serving a federal sentence. She doesn't get 2 bites at the apple just for committing 2 crimes.
Circuit Judge Chad Lovejoy reviewed the case and agreed with the prosecutor. He ruled that Holmes was not eligible for parole until November 2026. The judge pointed out that Holmes was not entitled to credit for both federal and state sentences at the same time.
Do you recall what your order was related to when she would serve her time and conviction on the murder?
Surely, yeah. Well, she had a prior conviction in federal court I understood was drugs, and she was serving that sentence at that time.
Adding to the controversy, Holmes has also been linked to the unsolved deaths of 4 people in the 2005 prom night murders. Although she has never been formally charged in that case, her name has repeatedly surfaced in connection with the investigation.
You agree with me that court speaks through its orders, right?
Absolutely.
So what is meant from this court is what is put down in those orders, right?
The parole hearing that took place in March 2025 was later declared null and void. A new hearing will be required in November 2026, at which time Holmes will again have the opportunity to request release. Wendy Morgan's family, while emotionally shaken by having to relive the case, expressed gratitude that justice was maintained.
Until I get to go to court and get some justice for my child, I'm never going to sleep on it.
Her aunt shared that despite the pain of revisiting such a traumatic time, she felt a deep sense of relief knowing the decision had been corrected.
When someone is eligible for parole, that it follows the law and follows the intent of that court. They are the deciders of the sentence, and the parole board needs to follow that, and I believe they're going to do that today.
Prosecutor Spears has since called for changes to the parole system in West Virginia. He stressed the need for better coordination between the courts, corrections officials, and victims' families to ensure such mistakes do not happen again. Holmes now remains behind bars, with her future once again uncertain as she waits for her next opportunity at parole in late 2026. George Belasco, an 88-year-old Parma man, was involved in a hit-and-run incident on March 21, 2025, which left a mother, Shalante Maddox, and her son, Genesis Ojikutu, injured. The accident took place outside a Mark's grocery store at 7511 West Ridgewood Drive, where Shalante was pushing her son in a stroller. Belasco's vehicle struck the stroller, overturning it and causing significant injuries to both mother and son. After the incident, the Parma Heights Police Department took over the investigation to avoid conflicts, as Belasco had ties to the Parma police. Surveillance footage from the scene confirmed that Belasco had struck the victims and failed to stop. On March 24, 2025, a grand jury indicted Belasco on 6 felony charges: 2 counts of vehicular assault, 2 counts of failure to stop after an accident, and 2 counts of failure to stop after an accident on a non-public road.
Michael Lear, 696-0900, on behalf of George Belasco, Your Honor. We've been in receipt of the indictment for more than 24 hours. We waive the reading of the indictment, enter a plea of not guilty. I do wish to be heard on bond, Your Honor. Your Honor, there is a bond recommendation of $10,000 personal recognizance, which we have no objection to, but there is also a request for GPS monitoring as well as court-supervised release. Your Honor, Mr. Belasco is 88 years old. He's been married for 65 years. He has 3 adult children, 6 grandchildren. He's a homeowner. He lives in Parma, Ohio. He's lived in the same house since 1969. I believe those bond conditions are unnecessary to secure Mr. Belasco's appearance in court, and we would respectfully request that the court just order the $10,000 personal recognizance bond.
Your Honor, Brendan Mackin for the state of Ohio. The state is asking for the defendant's driving privileges to be suspended as a condition of bond, and also a victim's mother is present would like to make a statement.
Belasco appeared in court for his arraignment on March 26, 2025. He pleaded not guilty to all charges. His defense attorney requested a personal recognizance bond of $10,000, arguing that strict conditions like GPS monitoring were unnecessary due to Belasco's age and stable family life. The prosecution, on the other hand, asked for stricter conditions, including GPS monitoring, home detention, and the suspension of Belasco's driving privileges, citing public safety concerns.
Over, let me circle that. All the left over the deputies. House or 2. Thank you. This is an assault case, not a homicide, correct?
Correct.
Good morning, Your Honor.
Good morning.
Ryan Doherty, RYANN, victim advocate with the prosecutor's office. I am here with the victim and the family of the victim. We would like to ask for a high bond, a GPS, home detention, as well as his driving privileges revoked. We believe that he's a danger to the community if he continues to drive. Something like this happening, more people are at risk. So we would like to ask for that GPS. And then the victim would like to speak as well.
I just would like to say, George,
No, right here.
I wish he just would have stopped. Just wish he would have stopped.
The victim's mother, Shalante Maddox, also addressed the court, urging for stricter conditions to prevent further harm.
This is a case where there's a defendant's driving that vehicle when the victim mother was pushing a cart with her 2-year-old son in it, and the defendant struck the cart, overturned the cart, and the child, 2-year-old child, ended up with a broken bone, broken right arm, and a hematoma to his forehead.
Okay, so it wasn't a vehicle.
Correct.
Okay.
And just quickly.
What road?
He moved on.
West Ridgewood in Parma. Crosswalk, sorry. Crosswalk, 7511 West Ridgewood in Parma.
Okay. Mr. Lear, there was something else?
Yeah, quickly, Your Honor. Your Honor, he has not been driving since the incident. His children are in possession of car keys, so he has not been driving, and they're making sure he doesn't drive.
Thanks for that. Shallow reassurance. Okay, we'll set Mr. Velasco's bond at $10,000. It'll be personal. You've already have no contact with the victim. Mr. Velasco, we will order that you surrender your driver's license. You not have driving privileges during the pendency of this case. We'll put you on court supervised release, but no GPS monitoring. Your case has been assigned to Deborah Turner. First pretrial is April 30th at 9 o'clock.
In his ruling, Judge David Mattia set Velasco's bond at $10,000 personal recognizance and ordered him to surrender his driver's license, prohibiting him from driving during the course of the case. Velasco was placed on court-supervised release without GPS monitoring. A pretrial hearing was scheduled for April 30th, 2025. At the pretrial hearing on April 30th, both the prosecution and defense reiterated their positions. The prosecution emphasized the potential danger Velasco posed if allowed to drive again, while the defense maintained that Velasco had not driven since the incident. Judge Mattia confirmed the previously set bond conditions, and the case is now awaiting trial. It was the morning of October 25th, 2013, in Cleveland, Ohio. Israel Thornton was on his way to school, excited and full of life. As he ran across Denison Avenue near West 37th Street to catch his bus, tragedy struck. A vehicle Israel and drove off without stopping. The boy died at the scene. Nearby surveillance footage captured the horrifying moment. The vehicle's headlights lit up Israel seconds before the impact. The driver briefly hit the brakes, then sped away. For months, the case went cold. The community grieved, and Israel's family was left with unanswered questions and unbearable pain. It wasn't until nearly 10 months later that police received a crucial tip through Crime Stoppers. The information led investigators to 43-year-old Jerome Lee. His 2012 Kia Sorento showed signs of front-end damage, and when questioned, Lee claimed he had been taking his father to a dialysis appointment the day of the incident, but the story didn't add up. Investigators learned Lee had taken steps to repair the car shortly after the crash, something they saw as a sign of guilt. Eventually, Lee was charged with leaving the scene of an accident. In August 2014, he agreed to a plea deal. In exchange for his guilty plea, prosecutors dropped the more serious charges, including vehicular homicide, citing a lack of evidence directly linking the crash to Israel's death.
I understand that when you have an accident, it could have been different if he had stopped. I know that y'all saying I didn't see the video because they was blocking it, but they saying he broke on the lights. It means he looked back. He had to see him ahead of time. He got scared or whatever, he kept going. You took him a year, I don't feel like that's enough. Because if he was sorry, he would have stopped. He had any kind of feelings or had a heart, he would have stopped. He would not have been caught another case or a fugitive and end up getting caught because he's in jail. Okay, now y'all, they saying ain't no evidence. Okay, he went and tried to get a car fixed. Okay.
Shanae Smith, S-H-A-N-A-E, last name Smith. Israel is my little cousin. Like my cousin Tito said, I feel like this guy is not sincere about his apology. He's shrugging his shoulders, body language. You get more time in jail for selling drugs. He took somebody's life. He do a year. He used to have the rest of his life. Israel does not have another chance. He has a lifetime. Israel only got one life and it was taken from him. And I just don't think a year is fair. If you guys can please take into consideration, like everyone said, if this was your family member or vice versa, no heart, no remorse. I don't accept the apology because it was not sincere. I'm sorry, but I don't. Israel's not here. He's gone, and a year is just not fair. Like, if you can please take into consideration how we feel, the pain that we're going through. Israel did not deserve that. Nobody deserves to have their life taken away from them.
During sentencing, the Thornton family expressed their heartbreak. When the sentence was announced, they were displeased.
You're responsible for your court costs. Therefore, you may be required a new community work service. Not more than 40 hours a month at $8 an hour reimbursement. You have a right to appeal your sentence and conviction. If you're indigent, let the court know within 30 days I'll assign an attorney to provide a transcript at state's expense. Your driver's license is suspended. It's a Class 5 driver's license suspension for 3 years. Your previous case, which occurred, you were placed on probation after this incident, so therefore, by law, it is not a violation of your probation in the new case. That is case 573-074, where you were placed on probation.
On March 5, 2015, Lee was sentenced to 1 year in prison. Since he had already served 217 days, he was ordered to complete the remaining 148 days behind bars. The judge acknowledged the Thornton family's heartbreak, but explained that the law limited the possible punishment due to the specific charge.
Like I said before, that judge should not have been on this case. That DUI, OVR he had, that judge should not have been on this case for Israel. For him to go and get 5 months, time served, he got a year. Time served 7 months, he got 5 more months to do. That judge should not have been on that case.
Because he wanted chance, because he wanted to be forgiven. That's why he's forgiving the next person, because he wanted to be forgiven, because what he did. That's exactly. Corrigan.
Judge Peter Corrigan got a DUI, OVI, and he was on probation when my nephew got killed, and he could end up on this case. He said, oh, I made a mistake. So this guy gonna say, oh, it was an accident, I'm sorry.
How hard? Then why you ain't turn yourself in?
He didn't turn himself in, but they said they didn't have no evidence, but they got the vehicle from a body shop where you took it to. You started saying, "Oh, I was taking my father to dialysis." Then why would you speed? They said he wasn't speeding, he wasn't drunk. How do you know when you got him? He was in jail.
What was that?
7 months later.
What was that like for you to see Jerome face to face?
Man, he was sitting there grinning. I was seeing his little grin on his face. If I had got close enough to my party, would have hit him. That's how pissed off I am.
Israel's father ran out?
Yeah, everybody, who would have stayed there? That judge should not have been on that case. I promise you that.
He was 5 years old. He was 5. At least
he just turned 5. He just turned 5.
At least he got 5 years.
All he wanted to do was go and learn.
All
he wanted to do was go to school. He wanted to catch a school bus. Okay, so somebody else ended up. But wait a minute. The point is, he know he hit him. They said you can see the tail lights come on. He looked back and then he took on off and turned the corner.
What was that like for you to see the video? Those were his last words.
I couldn't see because they were blocking the TV, but I tried to see something, but he was trying to show me before. But I'm sorry. I'm really sorry. And I know y'all probably ain't gonna say what I say about the judge, but I promise you, that judge should not have been on this case.
How do you guys move on from here? I mean,
oh, I can't even say. To be honest with you, I can't even say nothing else no more. I can't say no. Why the family in there crying like he finna get a life sentence? They better gone somewhere with that little bullshit on that crying.
What is this for your family though? In the memory?
Can't nobody bring Israel back. His sister seen me with the shirt. That's my brother. Okay, that's in front of my house. He got his book bag on, finna go to school. And now you telling this man he can't go to school no more. This man finna get 5 months left. And you think it's okay? And people get 6 months or a year for driving without no license. For loitering, you get a year for loitering. You get a ticket for walking across, for jaywalking. And you just killed somebody. It wasn't no accident. If you was not drunk, if you was not had no substance abuse in your system, you have no heart. You are heartless Because if you was sober and you hit this child and you walked around and then you kept going, you keep going, that means you was sober and you did it. You sober, you him, you ran up him sober. Are you serious?
No, she's not okay. Nobody's okay.
Are you?
On his record, he has somebody was on the run for doing it. He had just came home from jail. A lot of people that even just run the stop sign by having prior convictions get more time than that. He had a whole lot of prior convictions. Ain't no way by his history, his record, that he don't get more than a year, even if it wasn't death. Even if it wasn't this. He should have more years just because of his history. Just because of his history. It's not fair. Justice would never be served. Would never be served. We're paying taxes for what? We paying taxes for what? I'm downstairs in court for not making a complete sign not making a complete stop at a stop sign, and I'm looking at 6 months. My first offense. I'm looking at 6 months over a stop sign. Over a stop sign when this man avoided a school bus stop sign and somebody and was on the run for 8 months and didn't get time served. He don't even deserve the time served though. Time served? What time did he serve? He didn't serve no time. He was only 5 years old. He took everything away from all of us. All of us. It's people out here going crazy over a life. This little boy had no chance and will never have a chance. What this man do? What he gonna do? He gonna go kill somebody else. And then what? The next family gonna be standing here crying? Is that gonna be okay? Is that gonna be okay? And the crazy part about it is, I feel guilty. Why? Because I lived on 112th for Lorraine. I'll put my business out there. I lived on Lorraine, and the same Jerome Lee was shooting outside of my house. I called the police 3 times. Yes, I did 3 times. Police came. He got kicked out of that house. And then months later, he killed my nephew. I feel bad because I feel like if I didn't call the police on him, he would have still been living across the street. But it could have been one of my 4 kids. It could have been what my 4 kids did, though. But instead, it's my nephew. Still another life. And he get his life? That's not fair.
For Israel's family, the outcome felt hollow. They believed a longer sentence was deserved and that justice had not been fully served. Their pain was made worse by the knowledge that the man responsible would serve less than a year for what they saw as a life lost too soon. More than a decade later, Israel Thornton's story still serves as a heartbreaking reminder of how quickly lives can change and how hard justice can be to find when someone chooses to run. It was July 6, 2018, when a tragic and entirely preventable incident unfolded at Edgewater Beach in Cleveland, Ohio. Shad Howell, a boy living in a group home, drowned after being left unsupervised in the water. At the time, he was under the care of Christina Coleman, a 35-year-old employee of Quality Care Residential Homes. Coleman had been assigned to take Shad and a boy and a girl to the YMCA, an approved and supervised location. But instead of following the plan, she drove them to Edgewater Beach without authorization. The beach had no lifeguards on duty, and the water was rough, dangerous conditions for anyone. Despite knowing that Shad couldn't swim, Coleman allowed him and the others into the water and left them unattended. Soon after, Shad began to struggle. By the time help arrived, it was too late. His body was recovered from Lake Erie. Later that evening, following Shad's death, Coleman was fired. An investigation revealed that this wasn't the first time staff had taken boys and girls to that beach without proper permission. The Ohio Department of Jobs and Family Services launched a broader review of the group home's operations. In the months and years that followed, the case slowly moved through the legal system. Coleman was indicted on charges of involuntary manslaughter and child. In March 2023, nearly 5 years after the incident, she pleaded guilty to both charges.
All right, we are now on the record in the state of Ohio versus Christina Coleman. This is case number 633-659. On a prior date, Ms. Coleman had withdrawn her formal entered plea of not guilty and entered a plea of guilty in count 1 to involuntary manslaughter, felony of the first degree in violation of 2903.04a. She also entered a plea to endangering children in count 2, a felony of the third degree in violation of 2919.22a. Counsel had asked for the preparation of a pre-sentence investigation report. I'm in receipt of that document. I've made it available to the state of Ohio as well as defense counsel. I'm also in receipt of a court supervised release report. I've made that available to the state of Ohio as well as defense counsel.
The sentencing hearing took place on March 7, 2023. Shaud's family, still grieving, addressed the court with emotional statements.
Okay, go ahead, ma'am.
Shaud's mom married my son over 10 years ago, and since then, Shaud and his sisters have become my grandchildren, along with their younger brother Douglas, who is my biological grandson. Shaud loved his mom and his siblings, and all he wanted was to be with them, but due to circumstances out of his control,
If you could
they
slow
had
down
to
a little
be-
bit, please.
I'm sorry. Due to circumstances out of his control, they had to be split up. Aside from 2 months due to a glitch in the system, and the 4 days that he was in that group home, for the last 6 years, Shaud has always been with family. He had mental health issues and never should have been in a group home. We've always tried to keep him out of the foster care system. I'm here to speak on behalf of his sisters Morgan and London and his brother Douglas, which he called Scoop Scoop. Although the children didn't live together, they were frequently in contact with each other. Shaud set up roadblocks accounts so that they could play together over the web. My brother Emerson and I made sure that they went on outings and spent the night together. Just 2 weeks before his death, I took pictures of all of them playing basketball in my backyard. Shaud rode each of them on his back. We left my home and went to the park where they climbed trees, swung on the swings, and ran from the birds. I never would have thought that those pictures would be used weeks later at his funeral. Shaud was their big brother, their protector. Shaud had siblings that adored and that he adored and that absolutely adored him. Morgan said, having my brother around was like a dream come true because he was not only my brother, but my best friend. Before he died, I thought we were going to be together and have fun. When I have bad days, it's like he's there making me happy again. Shaud and I were very close. All of us were. The feelings about my brother's death is really hard. My brother will never be forgotten. When I think of my brother, it's really hard for me not to cry, whether I'm at home or at school. London said, I feel sad most of the time because my brother passed away by drowning at Edgewater Beach. I am sad about that because he was the oldest out of all of us. We went to the funeral and sat on the first row. What makes me happy is the fun memories, like going to the IX Center and spending time with each other. We would never fight or argue over things. We would even talk to each other over the phone. I love my brothers and sisters. Douglas said, Shaud was my hero. I love him. Since Shaud's death, they have all been in therapy. Douglas had had dreams that Shaud was alive, just to wake up and be reminded of the nightmare that he is still living. True justice can't be given today because regardless of the outcome, it won't bring them back. Their life will never be the same because a major piece of their puzzle is missing. Their older and much loved brother, Shaud.
Thank you, ma'am.
Mr. Harper. Dante Love.
How you doing? My name's Dante Love. Shaud, man, was a great kid. You know, he was strong, funny, and from the times that we had when he would come see me and talk to me, he would always brag about his brothers and sisters. That's all he cared about. And I'm truly miss him. And nothing. gonna miss my baby boy.
His aunt, Miriam Burtz, who had legal custody of him, shared memories of his personality and dreams. She read from a handwritten bucket list he had made. Among his wishes were to play football, swim with fish, and meet a celebrity. She spoke of his kind heart and the tight bond he shared with his family. His sister also spoke, telling Coleman directly, "He trusted you. We trusted you." When it was her turn to speak, Christina Coleman apologized, expressing regret and sorrow for what had happened.
Judgment at the time was not thinking that anything was going to happen to any of those kids. I always looked at those kids as my own, and at the time I just was going through so much in my own life, from losing my mom and my niece, everything. I just went through so much. My decision making wasn't the best at the time. I can't really talk, but I really apologize for ever leaving the scene, for anything, for everything. Just, I apologize.
Your Honor, in conclusion, I would like to say that I would hope that the court would take this case into consideration and give my client community control. We can't bring the child back. That's impossible. We apologize for whatever happened, and the fact that the prosecutor said she lied, I think that she was so distraught by the whole situation that she tried to remember it and tried to say whatever was the best thing that could come out of her mouth. She was supposed to get a slushie, and she didn't get that, and we all know the facts. We know the facts, and it's terrible. What she did is she went away and left them there. Now, there was 2 other children. I guess she assumed that they were going to help out, watch over this one child that was 13, and never dreamed in all the greatest imagination that this terrible thing was going to happen. There was lifeguards there, there was people there for security, there was everything that we could ask for, and she shouldn't have left there. That's correct. And we apologize for that. We apologize to the family, apologize for the loss of life, but we just ask that the court, this is a terrible thing, a terrible story. I can't imagine anything else happening. I just wish you would take into consideration what's happened here, what she says, and what we want to protect the public. And she'll never, of course, do this again. But by protecting the public or putting her in jail, I don't believe that's the right thing either. I think a community control and let her do something, whatever the court says. But and this is in the process of proceeding forward with it. We also would like to say that she is in a position where she has a job. The report shows that she's a manager at a family store. She works. She has a job. She does everything she can. She's got 4 children. One cannot be in, or 2 of them are under 18, so they can't come in the courtroom.
Her defense attorney asked the court to consider community control, essentially probation, arguing that Coleman had no prior criminal history and had shown genuine remorse. But Judge Sherry Mayday emphasized that despite Coleman's lack of intent to harm, her negligence had devastating consequences.
Both sides. Ms. Coleman doesn't have any significant record. She was working, has kids, a lapse in judgment. But counsel, you indicated her children are counting on her. Shad was counting on her to be there and watch. And that can't be overlooked. Counsel had agreed at the time of the plea that count 2 and count 1 would merge for sentencing purposes. Is that correct?
That is correct, Your Honor.
And the state is electing to go forward on count 1, correct?
Correct, Your Honor.
Ms. Coleman, again, I don't believe that you purposely went out there to cause harm to anybody. But you have to appreciate there needs to be a punishment for what occurred here. You understand that? The court has formulated its decision based upon the overriding principles and purposes of felony sentencing, which are to protect the public from future crime by the defendant or others, and to punish the offender using the minimum sanctions that the court determines accomplishes those purposes without imposing an unnecessary burden on state or local government resources. To achieve these purposes, the court has considered the need for incapacitation, deterrence, rehabilitation, and providing for restitution. The court has considered the relevant sentencing guidelines provided in 292911, 292912, 292913, as well as 292919. At this time, the court does not believe that a community control sanction would adequately protect the public. It would demean the seriousness of the offense. At this time, as to count 1, involuntary manslaughter, felony of the first degree, I am sentencing you to 3 years at the Ohio State Reformatory for Women. Count 2 will be merged into count 1 for sentencing purposes. Have a seat. Ma'am, upon your release from, relax. Upon your release from the institution, you are subject to 5 years of mandatory post-release control. That means that the adult parole authority, and not this court, will supervise you. They will give you terms and conditions you must follow. Should you fail to meet the terms and conditions of the adult parole authority, then they can modify and/or extend your supervision and make it more restricted. Incarcerate you for up to 1/2 the original sentence imposed by the court. Charge you with a new offense called escape, another felony, where you face additional prison time, and if you commit new crimes while on post-release control, you face the maximum penalty under the law for new crimes committed. I'm not going to impose any fines or costs. Given the sentence that you're going to have, you are now indigent. Your lawyer will remind you, your behavior at the institution will directly reflect whether this court would ever entertain any or early release. Do you understand that? So that motion is not before this court. I will always consider such motions when they're filed timely.
After considering the seriousness of the offense, the court determined that probation was not appropriate. The judge sentenced Christina Coleman to 3 years in prison at the Ohio Reformatory for Women for involuntary manslaughter. The child endangerment charge was merged into that sentence. Upon release, Coleman will face 5 years of mandatory post-release control, during which any violation could result in further prison time. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.